Assalamualaikum warahmatullahi wabarakatuh. I'm very quickly to all. Thank you for inviting for this section. And I am AHMAD who would like to present presentation entitled an insight into document examination and question documents in Syariah court. And as an introduction, the purpose of this study is to investigate the types and prevalence of document forgery in Syariah court, and also to examine the role of forensic document examination and expert opinion in addressing question document. And the key problem of this study is document forgery poses significant legal and procedural risk impacting rights and judicial integrity. Basically, the research objective for the study is again to identify the types of document forgery or forensic document examination present in Syariah court cases, and also to assess the extent of expert opinion in handling forgery cases, especially in Syariah court. And for the methodology, basically we use the qualitative methodology whereby an armchair research method and qualitative content analysis has been done towards 14 selected Syariah court cases. Mainly the cases were found throughout the study by using the library online databases from Jurnal Hukum, Current Law Journal, and also Syariah Law Reports and Malayan Law Journal. As the summary of the result for this study, we have concluded that there are several fields of forgery existed in constituent document, for example, in marriage cases, for example, in Khalid bin Yati lawan ketua pendakwa syariah Melaka, and the case of pendakwa syariah Kelantan lawan Mat Rahim Samad, dan satu lagi Abdul Halim bin Hashim against Azila binti Ramli, Rosniza binti Mustafa against Abu Bakar bin Dawam, Azimah binti Man, and Muhammad Hamdan bin Ismail. In the case of polygamy, Syariah prosecutor and Azlan Daniels bin Abdullah. In the case of distribution of property, hibah, AHMG and AGMG and others, MST Kulsum Bibi and another versus Muhammad Arif and others. Also in the case of distribution of property, case of Muhammad Salim bin Said and Tan Keng Ki, Sulaiman bin Ahmad, Ahmad bin Majid against Habibah, Abdul Majid, Jainuddin bin Anwar, and Khadijah binti A. Hijazi. Also in the case of distribution of property, Hafiz Pencarian, in the case of Sharifah Zainab and Ismail Fikri, distribution of property for wakaf, in the case of Majlis Agama Islam Negeri Pulau Pinang and Abdul Latif bin Hassan and another. So all of these 14 cases has been thoroughly analyzed, and we have come into several conclusions in regard with the existence of document forgery and also document examination in specific document question document. So these are our result. Case analysis 1. In the case of Khalid bin Yati lawan ketua pendakwa syariah Melaka, the appellant has been brought before the court for obtaining a marriage certificate to a false declaration using the identity card of another person. For that purpose, he has been lying to the future wife and in-laws, and also the imam and the doctor, to obtain the marriage certificate and HIV-free confirmation. And the appellant has been charged under Section 38 of the Islamic Family Law Enactment on 16th of July 2007. The fine 1,000 was retained, 1,000 ringgit was retained, and the imprisonment was dismissed since it is appellant first offence and there is no previous criminal record. And from this case, you can see the form of forgery that happened during the process of marriage or polygamy can be seen in the case where the appellant obtained a marriage certificate by making a false declaration using the identity card of another person. In the next case of Syariah prosecutor and Azlan Daniels bin Abdullah, the accused was married to Nur Aini binti Alias on 27th January 1985 in Penang, and the said marriage is still legal till today. And he had contracted a second marriage with Zarifah binti Abdul Muttalib on 8 March 8 March of 2000 at the Office of Islamic Religious Department in Kelantan. On requesting permission to contract the second marriage, the accused has made a false declaration that he was still single and was not previously married. This declaration was made in the appellant in the application form for males who were seeking permission to marry. Convicting the accused as charged, the court held that the act of accused making a false declaration, thereby deceiving the Islamic religious of his clan, was a serious offense which could not be condoned by the court. The effect of his action had not only affected his wives and their families, but also the religious officers, and further has tarnished the good image of the religious department and had ridiculed the laws and the Sharia. And in this case, the accused had made a false declaration that he was still single till the date of marriage, second marriage, and was not previously married when requesting permission to contract the second marriage. In the third case, the case of AHMT and AGMT and others, where the appellant challenged the validity of Form 14A to question whether or not a gift transaction existed. The court did not find any evidence showing that the appellant had lodged a police report on the alleged forgery of the deceased's fingerprint in the document, and that the appellant had not taken any action to challenge the validity of Form 14A. Therefore, the court held that the appellant's claim of the invalidity of the document was groundless. In this case, the validity of Form 14A in the gift or hibah transaction was challenged due to the alleged forgery of the deceased's fingerprint found in the document. The fourth case analysis involved in Muhammad Salim bin Said and others, and Tan Fin Ki and another appeal, where it concerned that fraudulent transfer of 3 pieces of land owned jointly by Shahid, Mah, and Yam to the respondents. The appellant alleged that the power of attorney and the memorandums of transfer were forged and applied to the High Court to set aside all the transfers and reinstate the names of original owners in the register. According to the appellants, the donor to the PA had passed away in 1964 and 1981 respectively, and would not have created the PA in favor of Shahid. In fact, Shahid had passed away in 1938 and 1939 and could not be the vendor who sold the properties to the respondent. The High Court dismissed the appeal, holding that the appellants had failed to prove fraud and forgery because they had failed to establish the relationship to the original registered owners of the 3 lots, and failed to prove that the original owners were dead when the PA was executed. However, the Court of Appeal allowed the appeals to set aside the High Court verdict, holding that the Faraid certificates were the best evidence in proving that the appellants were the rightful beneficiaries of the deceased. Besides, possession of the original deed was strong corroboration of evidence of Halimah and Mah daughter, and the death certificate showed without doubt that Mah and Yam died in 1964 and 1981 respectively, and the PA was used to transfer lots, was a forged document as the donors and donee were no longer alive when the PA was created. This instrument of transfer, repeatedly signed by the deceased, was a void instrument, being a document of transfer that bore a forged signature. The title over the properties was set aside, and this case involved a fraudulent transfer of the 3 pieces of land owned due to allegation that the power of attorney PA and the memorandums of transfer were forged. We go to the case analysis number 5. In the case of Sulaiman and others, beneficiaries for the estate of the deceased, Ma'in bin Muhammad, half portion, and beneficiaries of the estate of deceased, half portion held by Zabidah as administrators and trustee, and Ma'in bin Muhammad and others. The plaintiff sought for a declaration as to the status of the transfer of the land to the third defendant to be declared as null and void on account that the title of the land was acquired through fraud or forgery by the defendants to avoid instrument. The court held that the third defendant was not the first registered owner of the land, but the immediate purchaser of the land. The third defendant had acquired the title through fraud and forgery of the first and second defendants by means of a void instrument of transfers on ground of forgery. The deceased could not have executed the sale and purchase agreement, and the instrument nor could they have applied for an order for sale since they were long dead before 2013. The first defendant had admitted that he was not the real registered owner of the land and had unlawfully admitted to the particulars of fraud and forgery instrument of transfer and as co-vendor. The title acquired and now registered in the third defendant's name under the land could be defeated under section 3402B of the NLC for forgery and void instrument. The plaintiff had succeeded in proving forgery by the first and second defendants, and the third defendant need not be a party or privy to the forgery where forgery existed. This means that the plaintiff applied to the court to declare the transfer of the land to the third defendant, and it is null and void on account that the title of the land was acquired through fraud or forgery and through a void instrument. The sixth case of Sharifah Zainab and Ismail Fikri, the court stated that the forgery of content of document or any pleadings brought before the court could be deemed as content of court and is liable for further penalty and action based on section 229 of the Syariah Court Civil Procedure. The court civil procedure enactment of Selangor, the court shall have the jurisdiction to commence proceeding against any person for contempt of court and may in such proceeding make an order of committal for a period not exceeding 6 months or may impose a fine not exceeding 2,000 ringgit. The contract of a document tendered by the respondent is found to have been forged after an inspection conducted by the Jabatan Pentadbiran Bahagian Pengurusan Perolehan (DBP). In this case, the contract official document tendered by the respondent is found to be forged or altered by someone or after inspection by the Jabatan Pentadbiran Bahagian Pengurusan Perolehan (DBKL). Case number 7, Ahmad bin Abdul Majid lawan Habibah Abdul Majid and another is a case where the plaintiff applied to set aside the order of division of land issued by the land administrator. Because it was improperly obtained, the court held that since the defendant named the brother of the deceased as the hire and not the plaintiff, this was fraud deliberately committed by the defendant over the rights of plaintiff on the deceased estate. According to Hukum Syarak, when the deceased leave a son, the brother of the deceased has no right over the estate of the deceased. In the instance case, not only the defendant who was committed fraud, but also the brother of the deceased who has made a declaration that the deceased has no son and he is the hire, and that he disclaimed his right as the hire. The land administrator has given the order based on false document. Therefore, the order made based on such false document is void and invalid. In this case, the court held that since defendant named the brother of the deceased as the hire instead of plaintiff, this was fraud deliberately committed by defendant over the right of plaintiff on the deceased estate. Next case, pendakwa Syariah Kelantan lawan Rahim Zaman dan satu lagi is a criminal case where the two accused in this case were charged with an offence under section 91 and 92 of the Syariah Criminal Code for committing halwal. So the accused raised a defence that they were illegally married at the material time and had produced a nikah document which indicated that they had solemnized their marriage in Thailand. The prosecutor did not seek to challenge the authenticity of the documents, but applied for an adjournment to enable it to carry out an investigation over the nikah documents. However, the prosecution failed to provide the court with the outcome of its investigation, and the prosecution had failed to show that the nikah documents as produced by the accused were tainted with forgery or obtained through forgery and or improper means. The nikah documents in question were sufficiently convincing to the court by which the first and second accused were lawfully married. So, in this case, pendakwa Syariah Kelantan had applied for an adjournment to enable it to carry out an investigation over the nikah documents. So they said it has been altered and forged, and the document has involved some forgeries, and they failed to prove the kind of forgeries in the nikah documents produced by the accused, showing that they had solemnized their marriage in Thailand, and the court held that the second and first accused were lawfully married. Case number 9, Zainuddin Anwar and Khadijah. In this case, the plaintiff applied for the private KBX entered over the properties held under GM 1848 and GM 1918 to be retained until the originating summons are heard and finally disposed of and until the properties are divided among the entitled heirs according to the Fara'id certificate. However, the validity of Fara'id certificate is disputed due to the absence of seal from Syariah courts. Besides, there is no verification from the authorities that the copy submitted is the valid one. The court found that the plaintiff has failed to prove that it is the legitimate grandson of the deceased and then dismissed the application as it does not have any interest to enter the tablet for the property. So in this case, they failed to get any verification from the authorities for the Fara'id certificate, and there are some the seal from Syariah court has absent in the certificate, and the question document of Fara'id certificate is disputed due to the absence of seal and also absence of verification from the authorities. So the court dismissed the application. Number 10, in the case of Ms. Kulsum Bibi, the lower court ruled that the gift deed executed by the deceased in favor of his brothers was forged and fictitious, thus invalid and unenforceable as against the plaintiff. On appeal, the High Court, on the decision of the lower court, questioned the decision of the lower court on the grounds that fraud will not be an issue because it had not been alleged in the plea, and secondly, the gift deed was valid, since Marvel Mount had not been proved by the plaintiff. The plaintiff appealed against the High Court decision. Supreme Court held that the gift in this case was fraudulent, and the very transaction of gift in original has not been proved by the so-called holdings, and therefore the gift becomes non-existent and nullified regardless of whether it is made during Marvel Mount. So the plaintiff, okay, the High Court quashed the decision of lower court on the ground that fraud could not be an issue because it had not been alleged in the claim, and secondly, the gift deed was valid since now the amount had not been proved by the plaintiff. So the plaintiff failed to prove that failed to prove the amount, and therefore the gift becomes nullified, non-existent, regardless of whether it is made during the amount. Case of Abdul Halim bin Hashmi, the first applicant and the second one who were married on 2005 and were blessed with 3 children. Before the marriage, the first applicant already had a wife, and the second applicant still had a father related to Kelantan, who was also the one who was there for the second applicant. The applicants later received a letter from the Administration Office of Islamic Office of Gajah stating that the applicant's certificate of marriage was false and was never issued by any deputy registrar of the Qaryah in the area. The applicant had then filed an application to affirm the marriage and legitimize the children resulting from the marriage. One of the important issues tried in the court is whether the applicant's marriage was lawful under Hukum Syara or not. The court had then one of the requirements of the marriage, which was wali, was not fulfilled, thus the marriage was found to be invalid. The court found that there was no utterance of representative of the wali, meaning there is no wakalah of wali from the wali to the marriage official, the nikah, because the wali in his evidence clearly stated that he did not know about the marriage until it was told by the applicant. The officer in charge is unaccredited, and this statement is supported by a marriage confirmation letter issued by the Kampung Gajah Islamic Religious, dated 2012, confirming that the marriage certificate obtained by the applicant was false and the marriage was conducted by syndicate by submitting to the court a certificate of marriage dated 23 October 2012. The marriage certificate has never been issued by any assistant registrar in such area. In case of Rosniza and Abu Bakar, the applicant and respondent were married on 1st March 1996. The marriage was solemnized by an assistant imam in Masjid Ubaidah, Kuala Lumpur, and was witnessed by 2 male witnesses. The applicant contested that she had not authorized the said imam to solemnize the marriage. An applicant discovered that her marriage certificate was fake, and there were no record of her marriage to be responded to the search at Jawi. The court held that the marriage was voidable and could not be registered since one of the 5 essential conditions of the marriage, which is wali, had not been established. During the solemnization of the marriage, the applicant still had her father as her guardian. However, the applicant had never made any application for permission to marry nor application for wali hakim from the Jawi. Therefore, the solemnization was invalid and could not be registered. Case Nur Azimah and Muhammad Hamdan, the court declared that the applicant marriage to the respondent as voidable, and it can neither be recognized nor registered since the applicant has failed to fulfill the 5th pillar of the marriage, the presence of wali. The applicant doubted the status of the marriage and thus made inquiry with Jawi, and it was then disclosed that there was no record of registration of the marriage, and further, the existing marriage certificate was confirmed as fake. In another case of Majlis Agama Islam, Pulau Pinang, against and Abdul Latif bin Hassan, Haji Idris granted Islam to Haji Abdul Rashid by a deed poll and indenture to hold it on trust for the purpose of building the land for a mosque and the Muslim burial ground. So the Fatwa Committee issued a fatwa declaring the land was as wakaf. The plaintiff is declared under Section 9 of the Administration of Religion of Islam, State of Penang, to be the sole trustee of all wakaf property in the State of Penang. The first defendant had the land transferred to his name, and after obtaining the court sanction, sold the land to the second defendant. The plaintiff contended that the sale contravening Islamic law relating to wakaf and later filed an extended suit to set aside all dealings with the land with the defendant or any other party. The defendants failed to satisfy the court that the deed poll and the indenture were not genuine document. So the plaintiff, on the other hand, had successfully proved that the said document were validly made under and executed by the Haji Idris. The court held that any order that granted the title of the land to other party than the plaintiff was invalid, null, and void, and had to be set aside. There are several types of forgery involved in this 14 document. In the case of marriage and polygamy, The first one is acquire forged marriage certificate using another person's identity, and also forced separation, forged marriage certificate due to non-fulfillment of pillars in marriage, forged signature fake certificate, and etc. Distribution of property also involve forged fingerprint, forged power of attorney, and also memorandum of transfer, ex parte order over the title of the land obtained through fraud or forgery, forged document of contract offer, fraudulent application for the order of division of property, invalid federal aid certificate, also forged gift deeds transaction. Based on the previous studies, there is no doubt that forensic document examination is advantageous to the justice system, and the problem of identification in cases such as forgery, fraudulent signature, and other questioned document can be solved by conducting a scientific examination. And forensic evidence implies an expert scientific opinion which assists the court as well in many ways to implement justice. And interestingly, the grounds of admissibility of forensic evidence can be found in the prophetic tradition, and also from the companions' consensus, and from the ijma and the interpretation of jurists from the ijtihad. And being one of the branches in forensic science, it has been found that forensic document examination is significantly applicable and admissible as an expert opinion. Also, this can help the court in making the right decision, making the most just decision on the matters beyond the judge's knowledge. And also in Islamic law of evidence as known as al-bayinah, there is a comprehensive term which refers to anything which may lead to clarify, elucidate, or explain any right or any matters or interest in a dispute. And while qarinah means anything which may be used by proof or evidence to establish the existence or non-existence of thing. And therefore the forensic examination and explanation can also serve as corroborative evidence in court of justice. The legal provision on expert opinion is specifically mentioned under the Section 33 of Syariah Court Evidence Act 1997, and it is stated that when the court has to form an opinion upon any point of law, science, or art, or has to identify the genuineness of handwriting or finger impression, or relating to determination of nasab, the opinion upon that point of person specifically skilled in that foreign law, science of art, or impression of identity or genuineness of handwriting and determination of nasab are known as qarinah, and this provide the opportunities of the parties to present expert opinion based on the results of scientific examination. And in order to be relevant and admissible in court, it must fall within the category of expert opinion stipulated by this provision. And it's also clear that the evidence from the expert opinion are admissible in court, and also a form of qarinah. And the principle established in the field of forensic document or document examination rely upon the forensic document examiners play significant roles in uncover the forged documents. And in forensic science, the primary idea to compare whatever is unknown or questioned with known standards is in order to make an identification. And for example, in fingerprinting, a latent print discovered at the scene of a crime is matched to fingerprint on file or recently acquired from suspect. And the same is obvious when it comes to handwriting or fingerprint analysis to determine a suspect guilt or innocence. Any question writing or any question on the fingerprint or any question on the seal is compared to known examples of his or her handwriting or painting or any kind of specific seal from the authorities. And some document examination can be performed without causing harm to the specimen under test, while others require the removal and destruction of a small portion of the specimen, and also non-destructive techniques are preferred over chemical analysis or destructive tests. Each analysis of question document begins with simple optical methods such as UV test, also filtered or unfiltered artificial light or IR infrared part of the electromagnetic spectrum. And this method examine the color and the brightness of the ink on paper, as well as security fibers in papers, and also aid to the identification of alterated ink, erasures, and also substitution, and to distinguish between inks that appear to be of the same color. And the result seems to consistent to the application of forensic science and it has its own role in evidencing cases, both criminal and mild. It is beyond the scope of this study to fully discuss other topics in forensic science, such as the DNA, ballistic, and etc. But uh, it is a hope to see future research direction to explore more on the forensic field and relate it with Syariah court or jurisdiction. And it is admissible and also applicable for forensic document examination in the Syariah court, since it falls under the category of expert opinion, as we have mentioned before, and also Islamic law recognizes expert opinion as one of the means of proof based on the Syariah Court Evidence Act 1997, and it can fall also under the Qarina and circumstantial evidence. Other than that, was consideration as expert opinion may include various definitions and meaning based on Syariah cases. Undoubtedly, the principles identified in forensic document examination are applicable and admissible in Syariah court. Okay, as a conclusion, this study recommend to extend the integration between forensic science, society, and forensic document examination, and make it as a standard or procedure in Syariah courts, and to enhance the expert involvement in giving testimony of or giving opinion in court, and it would be better to develop guideline and mechanism to have some clear protocols with employing forensic document examination in legal proceedings, especially in Syariah court. As a conclusion, forgery in document is a serious issue that threaten the integrity of Syariah court ruling. There might be cases that might be decided unjust due to the forged document. Forensic document examination is essential to enhance liability and address procedural gaps and also uphold justice in legal proceeding. And lastly, to adopt forensic practices to combat document forgery and to clearly dismiss the question document in court, especially in Syariah court. That's all from me. If you have any question, and you can submit a question under the comment section. And also thank you for your time and then with your interest for this presentation. With that, I thank you. Assalamualaikum warahmatullahi wabarakatuh.